The arrest of Romea Öztürk, a graduate student and foreign national from Turkey, has drawn unprecedented attention to the boundaries of free speech and the exercise of executive authority in the United States. Öztürk, a promising scholar enrolled at Tufts University, had written an op-ed in the campus newspaper in March of 2024 addressing sensitive international and political topics that, while controversial, fell squarely within the scope of protected speech under the First Amendment. What followed her public expression, however, shocked both legal scholars and human rights advocates alike. In March 2025, the U.S. State Department, acting under the discretionary authority of the Secretary of State, revoked her student visa. The procedural irregularities and subsequent enforcement actions surrounding this revocation raised immediate questions about the limits of executive power, the sanctity of constitutional rights, and the treatment of foreign nationals in the United States. According to reports and internal memos obtained by investigative journalists, the revocation of Öztürk's visa was not grounded in allegations of violence, terrorism, or any other conventional security threat. Instead, it appears to have been triggered solely by her authorship of the op-ed, a fact confirmed by subsequent federal court proceedings. Mere days after the visa was revoked, armed in masked plainclothes, officers apprehended Öztürk on a public street, transporting her to a detention facility in Louisiana. She was denied immediate access to legal counsel for nearly 24 hours, raising further alarm among civil liberties organizations. The combination of administrative action and paramilitary enforcement suggested a punitive measure directed at speech itself, rather than any legitimate threat to public safety. The case quickly became a focal point during a congressional hearing in which Representative Jeepel, a member of the House of Representatives, directly questioned Secretary Marco Rubio, who held authority over the visa revocation. In a tense exchange, Jeepel confronted Rubio on the factual circumstances of Öztürk's arrest, asking pointedly whether the op-ed she had written could legitimately be construed as a national security threat. Rubio's responses, characterized by many observers as evasive and defensive, relied on the argument that student visas are discretionary and that the State Department is empowered by statute to deny or revoke visas to any individual deemed potentially harmful to U.S. interests. Representative Jeepel's questioning, however, highlighted a critical distinction that underpins the American legal framework. While visas may indeed be considered privilege and not an inherent right, the First Amendment guarantees protection of free speech regardless of one's immigration status. Jeepel pressed Rubio repeatedly on this point, emphasizing that Öztürk had committed no crime, engaged in no violent activity, and posed no demonstrable threat. The federal court later underscored this reality, noting explicitly that the sole basis for the government's detention appeared to be her authorship of the opinion piece. The hearing underscored a fundamental tension between statutory authority and constitutional constraints, a tension that lies at the heart of this case. In his testimony, Rubio insisted that statutory law grants the Secretary of State broad discretion in visa determinations, suggesting that such discretion might, in certain circumstances, supersede traditional constitutional protections. Legal experts immediately noted the problematic nature of this assertion, as the Constitution explicitly occupies the highest legal authority in the United States. Statutes enacted by Congress cannot override constitutional protections. Rather, they operate within the limits defined by the Constitution. The notion that an executive officer could target an individual for lawful speech, invoking visa revocation as the instrument, raises profound questions about the potential for abuse of statutory discretion in the absence of robust judicial oversight. The ostensible rationale for the extreme measures taken against Öztürk, the deployment of masked and armed officers, was similarly scrutinized during the hearing. Rubio distanced himself from the operational aspects, claiming that his office was responsible only for the visa revocation, not the physical apprehension of the student. However, Jeepel pressed the point, emphasizing that such a dramatic enforcement response was unprecedented for the mere writing of an op-ed. Comparative analysis of law enforcement practices reveals that federal agents routinely arrest individuals accused of violent crimes, organized criminal activity, and domestic terrorism without concealing their identities in such extreme fashion. The selective use of masked agents in Öztürk's case suggested an intent to intimidate or send a chilling message, rather than execute a standard law enforcement procedure. The hearing further explored inconsistencies in enforcement policies, with Representative Jeepel contrasting the treatment of Osterk with cases in which other individuals, including those expressing overtly discriminatory or incendiary views, were granted entry or asylum in the United States. Such comparisons highlighted the potential for ideological bias in the application of visa laws, and the troubling prospect that certain forms of political expression might be singled out for punitive action. Rubio's insistence that discretion allows him to act against speech deemed destabilizing effectively reframed the debate from one of process to one of principle. Can the executive branch legitimately punish expression by leveraging immigration authority as a tool of censorship? Underlying the legal and procedural arguments was the human dimension of the case. Osterk's arrest and detention imposed immediate and profound consequences on her life. She was separated from her academic community, denied immediate legal representation, and subjected to the uncertainty and indignity of incarceration. For a graduate student engaged in scholarly work and public discourse, these measures represented a stark disruption of both professional and personal trajectories. The broader implications extend beyond Osterk alone, signaling to foreign students, academics, and journalists that expression, however lawful and measured, could be grounds for punitive action under U.S. immigration law. The congressional hearing served as a critical forum for examining these issues in real time. Representative Jeepel's persistent inquiries forced Rubio to confront the legal and ethical implications of the government's actions. While Rubio relied heavily on statutory authority and the framing of visas as a privilege, Jeepel emphasized the enduring supremacy of constitutional protections and the non-negotiable nature of due process. This clash of interpretations, unfolding before cameras and the public record, underscored the broader stakes. The case of Romeo Osterk was not simply an administrative dispute over immigration. It represented a litmus test for the resilience of free speech, due process, and constitutional governance in the United States. The case of Romeo Osterk exposes a tension at the very heart of American governance. The boundary between statutory discretion granted to executive authorities and the constitutional protections guaranteed to every person within U.S. jurisdiction. At the center of this tension lies the First Amendment, which unequivocally states that Congress shall make no law abridging the freedom of speech. While the amendment's text directly addresses congressional action, the Supreme Court has consistently interpreted its protections to extend to all branches of government, ensuring that executive actions cannot circumvent the constitutional guarantee of free expression. Osterk's experience, her visa revoked and subsequent detention solely for authorship of a controversial op-ed, poses an urgent question. Can the Secretary of State invoke statutory authority to override fundamental rights guaranteed by the Constitution? To analyze this, one must first understand the statutory framework that governs visa issuance and revocation. The Immigration and Nationality Act, INA, grants the Secretary of State broad discretion to deny or revoke visas when an individual is considered inadmissible or a threat to national security or public safety. In ordinary circumstances, this discretion is exercised to prevent entry of individuals engaged in criminal activity, terrorism, espionage, or other clearly defined threats. However, the statute does not provide carte blanche to target lawful speech or expression. The INA's language, while permissive, cannot and legally does not supersede constitutional safeguards. Any interpretation suggesting that statutory authority allows the government to punish a person for political expression directly conflicts with the First Amendment's plain text and historical jurisprudence. Historical precedent reinforces a principle that constitutional rights constrain executive discretion. In Brandenburg v. Ohio, 1969, the Supreme Court established that speech advocating illegal action cannot be prohibited unless it's directed to inciting imminent lawless action and is likely to produce such action. Osterk's op-ed, by contrast, contained no calls to violence or subversion. Its content, even if politically provocative, falls squarely within the category of protected speech. Moreover, the use of immigration law as a mechanism for punitive action against speech aligns with no accepted legal standard. Scholars have long warned against the backdoor suppression of speech via administrative powers, recognizing that executive discretion, if unchecked, can become a tool for ideological enforcement rather than public safety. During the congressional hearing, Representative Jeepel repeatedly confronted Secretary Rubio on this fundamental issue, attempting to delineate between legitimate administrative authority and unconstitutional action. Rubio's insistence that student visas are privileges subject to revocation ignores the critical nuance that, while the visa itself is discretionary, the conditions under which it may be revoked cannot infringe upon fundamental rights. Constitutional law does not make the issuance of a visa a pretext for abridging speech. The privilege of entering the United States does not extinguish the First Amendment protections that apply to individuals while within U.S. jurisdiction. To argue otherwise would invert the hierarchy of law, placing statutory discretion above constitutional guarantees, a position that has no grounding in either precedent or principle. The Supreme Court has consistently held that statutes must be interpreted in a manner consistent with constitutional rights wherever possible. In Yickle v. Hopkins, 1886, the court affirmed that the Constitution, as well as the law, applies to all persons within the United States, regardless of nationality. Osterk, as a foreign student on a temporary visa, is unequivocally covered by this principle. The INA's discretionary provisions do not grant the executive branch authority to target her for expressing opinions, no matter how controversial. Legal scholars analyzing this case have emphasized that using visa revocation as a tool to silence dissent constitutes a dangerous expansion of executive power, potentially undermining the foundational principle that free expression cannot be curtailed absent compelling and narrowly tailored justification. Beyond statutory interpretation, the case raises critical questions about due process. The Fifth Amendment guarantees that no person shall be deprived of life, liberty, or property without due process of law. Osterk's detention, following the revocation of her visa, presents a textbook instance of deprivation of liberty without meaningful procedural safeguards. She was taken from a public street by armed masked officers, held incommunicado for nearly 24 hours, and denied immediate access to legal counsel. Due process is not suspended for non-citizens or visa holders. The Supreme Court has long held in cases such as Advitas v. Davis, 2001, and Nguyen v. INS 2001, that procedural protections extend to individuals facing governmental deprivation of liberty, regardless of immigration status. Osterk's treatment, therefore, implicates not only free speech rights, but also the procedural guarantees designed to prevent arbitrary executive action. The nature of the executive argument in Osterk's case reveals a troubling philosophical shift. Rubio repeatedly emphasized discretionary authority and statutory power, framing the visa as a privilege rather than a right. While legally accurate insofar as the government is not constitutionally required to issue a visa, this framing dangerously conflates administrative discretion with license to suppress constitutionally protected conduct. By suggesting that statutory power could override First Amendment protections, the argument implicitly endorses selective enforcement based on ideological criteria. Legal experts have warned that if allowed to stand unchallenged, such reasoning could set a precedent whereby any individual, citizen or non-citizen, could face punitive measures for expression deemed objectionable by the executive branch. The implications extend far beyond Osterk herself, potentially chilling speech across academic, journalistic, and activist communities. Scholars of administrative law further note that the exercise of executive discretion must be reasonable and based on legitimate government interests. Courts have repeatedly struck down actions that appear motivated by retaliation or ideological bias. The Osterk case, in which the government explicitly acted in response to the content of her op-ed, appears to contravene this principle. The Office of Legal Counsel, in several historical memoranda, has emphasized that content-based discrimination in administrative enforcement is constitutionally suspect. Revoking a visa based solely on an individual's expression is therefore not only ethically questionable, but also legally indefensible under established constitutional doctrine. Comparative analysis also underscores the unprecedented nature of this action. Historically, the U.S. government has faced challenges in balancing national security concerns with free speech rights, particularly in cases involving foreign nationals. The Japanese internment during World War II, while different in context, remains a cautionary tale of overreach in the name of national security. Contemporary scholarship emphasizes that modern administrative discretion, especially when exercised in secrecy or with paramilitary enforcement, must be scrutinized against historical lessons to prevent abuse. Osterk's detention, effectively punitive, ideologically motivated, and devoid of immediate due process, resonates with these historical warnings and highlights the ongoing tension between executive power and civil liberties. Moreover, the invocation of national security as justification in Osterk's case is highly tenuous. Secretary Rubio suggested that revoking the visa was necessary to protect U.S. interests, implying that the op-ed itself posed a threat. Legal analysis of such claims shows that the mere expression of controversial opinions, without evidence of coordination with hostile actors or incitement of violence, cannot constitute a credible threat to national security. The courts have consistently required concrete, demonstrable harms before upholding government actions that infringe upon fundamental rights. The lack of such evidence in Osterk's situation underscores the constitutional infirmity of the government's position. The academic community has been particularly vocal about the chilling effect this case could produce. Universities and research institutions rely on the free exchange of ideas, including critical perspectives on policy, international affairs, and societal norms. If visa holders can be arbitrarily penalized for scholarly expression, the intellectual independence of U.S. higher education is placed at risk. Scholars note that the exercise of executive discretion in this context, particularly when coupled with enforcement actions that are secretive and intimidating, undermines the foundational principles of academic freedom. From a constitutional law perspective, the hierarchy of legal authority is unambiguous. The Constitution reigns supreme. Statutes operate within its framework, and executive discretion must conform to both. Any suggestion that discretionary visa authority could override First Amendment protections is legally unsupportable. Experts in administrative and constitutional law stress that such actions, if upheld or normalized, could create a dangerous precedent for content-based discrimination by the government, eroding public confidence in the fairness and impartiality of administrative processes. Finally, the implications of the Osterk case extend to international perception and diplomacy. The United States has long positioned itself as a global defender of free speech and academic freedom. Arbitrary actions against foreign students for lawful expression risk damaging the country's credibility, creating diplomatic friction, and discouraging international students from studying in the U.S. at a time when global talent is critical to research, innovation, and higher education. The constitutional stakes, the legal precedents, and the broader societal consequences converge to make Osterk's case a watershed moment in understanding the limits of executive power vis-a-vis the First Amendment. Romeo Osterk's story is not simply a case study in law and constitutional principle. It is a profoundly human narrative of disruption, fear, and resilience. A graduate student originally from Turkey, Osterk had come to the United States to pursue advanced studies in political science and international relations at Tufts University. From the outset, her academic record was exemplary. She excelled in coursework, participated actively in research initiatives, and contributed meaningfully to debates on international diplomacy and policy ethics. Her presence on campus represented both the intellectual vibrancy of international student communities and the United States' long-standing tradition of welcoming scholars from around the globe. The op-ed that triggered the State Department's action was written as part of her scholarly engagement with contemporary global issues. Published in March 2024, the article offered a critical analysis of certain international policies and their socio-political consequences. Its tone was measured, analytical, and framed within academic discourse. It did not advocate violence, terrorism, or illegal activity. For Osterk, writing this op-ed was an extension of her education and civic engagement, a practice encouraged in universities worldwide. Yet, in March 2025, her entire trajectory changed in an instant. A revocation notice for her student visa arrived, and days later, masked and armed officers detained her on a public street, transporting her to a detention facility hundreds of miles from her university community. The immediate impact on Osterk was devastating. Removed from her campus environment, she was abruptly separated from colleagues, mentors, and friends who had been central to her personal and academic growth. The detention process, conducted without access to legal counsel for almost 24 hours, subjected her to both physical and psychological strain. Osterk's personal account, later recorded through her attorney, described feelings of disorientation, fear, and profound vulnerability, emotions compounded by the knowledge that she had committed no crime. This period of uncertainty and deprivation underscores the tangible human cost of administrative actions that target lawful expression. Detention, even temporary, carries a heavy burden on mental health. Experts in psychology and criminal justice note that sudden loss of liberty, combined with opaque legal procedures and the presence of armed personnel, can induce acute stress reactions, anxiety disorders, and lasting trauma. For a young scholar like Osterk, who had relied on stability and predictability to pursue rigorous academic work, this intrusion represented not merely inconvenience, but a fundamental disruption of her ability to function and thrive. Colleagues at Tufts University reported shock and disbelief at the severity of the government's actions, describing the incident as an affront not only to Osterk, but to the principles of justice and academic freedom. Beyond the immediate psychological impact, Osterk faced significant academic and professional consequences. Graduate programs are demanding, requiring consistent engagement in research, seminars, and collaborative projects. Her abrupt removal created gaps in coursework, delayed her research timelines, and placed her scholarship in jeopardy. Faculty members expressed concern that prolonged absence could compromise her eligibility for grants, fellowships, and future employment opportunities. For Osterk, the revocation of a visa and forced detention represented a multi-layered assault on her intellectual development, career trajectory, and professional aspirations. The procedural irregularities surrounding her detention magnified the human cost. Unlike routine arrests, Osterk was apprehended by masked, armed agents whose identities were concealed. This secrecy contributed to a sense of isolation and fear. Legal experts have emphasized that access to counsel is a foundational safeguard against abuse. Osterk's near 24-hour deprivation of legal guidance not only violated established norms, but exacerbated the stress and uncertainty of her detention. The experience underscores the intersection between administrative discretion and human vulnerability. When executive power is exercised without transparency or procedural protections, the personal toll on those affected is immense. Family and community impact further illustrate the breadth of human cost. Osterk's relatives, both in the United States and abroad, experienced profound anxiety, confusion, and helplessness. Family members reported multiple attempts to ascertain her whereabouts and legal status, facing bureaucratic delays and inconsistent information from federal agencies. For immigrant families and international communities, such experiences evoke fear that legal protections and human rights are contingent upon administrative discretion, rather than universally upheld principles. In Osterk's case, the family endured weeks of uncertainty, illustrating how governmental actions extend their impact far beyond the immediate individual. The social dimensions of Osterk's removal are equally significant. Universities are ecosystems of collaboration, dialogue, and intellectual exchange. When a student is suddenly removed under circumstances linked to their expression of ideas, the entire academic environment is affected. Peers and faculty members reported heightened caution in discussing politically sensitive topics, fearing that future engagement could trigger scrutiny or reprisal. Osterk's detention thus had a chilling effect, suppressing the very discourse that is central to the mission of higher education. Scholars of academic freedom have noted that such chilling effects are among the most insidious consequences of politically motivated administrative actions, as they erode the open exchange of ideas over time. The federal court's later decision to order Osterk's release provides a partial corrective to the immediate harms, but it does not erase the disruption, stress, and reputational damage she experienced. Courts highlighted that no evidence suggests that Osterk posed a threat to national security, emphasizing that her detention was premised solely on authorship of an opinion piece. Even so, the delay in justice, measured in weeks of uncertainty, and the psychological toll of detention, illustrates how human costs are compounded when legal safeguards are bypassed or delayed. Osterk's personal story exemplifies the broader principle that when administrative action targets lawful speech, the consequences are felt on individual, community, and institutional levels. Internationally, Osterk's experience reverberates as a cautionary tale. Students from around the world look to the United States as a destination for advanced education, attracted by the promise of academic freedom and intellectual engagement. When visa revocation and detention are wielded against individuals for lawful expression, the message is stark. Intellectual inquiry and political commentary are subject to the approval of administrative authorities. Such a perception threatens the global reputation of U.S. universities and the broader commitment to open academic exchange, potentially discouraging top-tier scholars from pursuing opportunities in the United States. The human cost, in this sense, is both personal and geopolitical. The case also highlights the cumulative stress imposed on foreign students navigating U.S. immigration law. International students often operate under tight visa requirements, with limited flexibility to challenge administrative decisions. Osterk's ordeal illustrates the vulnerabilities inherent in this system. Without legal recourse or timely information, a student can find themselves subject to coercive actions that disrupt life, education, and personal security. Human rights organizations have expressed concern that such practices, even if rare, establish a precedent that allows administrative discretion to override fundamental protections in ways that disproportionately affect vulnerable populations. The narrative of Osterk's detention is further complicated by the opacity of enforcement actions. The deployment of masked, armed agents introduce an element of theatrical intimidation, signaling that even lawful behavior could trigger extraordinary force. Psychologists and legal analysts alike have noted that the psychological effect of being apprehended by masked officers is profound. It induces fear, uncertainty, and a sense of helplessness, even in the absence of physical harm. For Osterk, the experience represented an abrupt confrontation with the power of the state, a vivid demonstration of the consequences of expression in a context where legal and constitutional protections are contested or ignored. Despite these profound challenges, Osterk's response demonstrates remarkable resilience. Once released, she returned to her academic work with renewed determination, engaging with advocacy groups, legal organizations, and human rights networks to document her experience and highlight broader implications for free speech and academic freedom. Her story has inspired debate in policy circles, media, and universities, catalyzing efforts to ensure that other students are not subjected to similar treatment. Osterk's personal experience thus becomes a lens through which the broader consequences of executive power and administrative discretion are examined, emphasizing the tangible stakes of policy decisions on individual lives. Finally, Osterk's case underscores the importance of legal and civic awareness. Her ordeal illustrates that constitutional protections and due process are not abstract concepts. They have concrete consequences in the lives of individuals. When legal mechanisms are bypassed or executive discretion is exercised without accountability, the human cost is immediate, severe, and far-reaching. Osterk's story serves as a reminder that safeguarding civil liberties requires vigilance, advocacy, and a commitment to holding authorities accountable for actions that impact the lives of real people.